All right, let's pick up on that story about the conviction of the EFF leader, Julius Malema, on firearm possession and unlawful discharge charges. I'm joined now by Pierre Venter to unpack it all. Pierre, good afternoon, and thank you for joining us here on the show. So let's talk about the elements that were in play as the magistrate delivered that judgment. It took about 3 days because the magistrate read the entirety of the testimony, cross-examination and the like into the record before finally coming on day 3 to an evaluation of what he had heard, what she had heard during the course of the trial. What swung it in the favor of the prosecution having dispensed with its responsibility to prove Mr. Malema's guilt beyond a reasonable doubt?
Good afternoon, and thanks for having me. This specific judgment was based primarily on circumstantial evidence, and the magistrate gave a proper, thorough judgment on the law or the doctrine of common purpose or circumstantial evidence in our country. And I think that is, at the end of the day, what she based it on, is saying that if you take all the evidence that was proved by the state together, it shows beyond a reasonable doubt that Mr. Malema did indeed commit these offences. We must remember that that's why it took so long to give the judgment. There's no direct evidence to this offence. You had to take all the circumstances that was presented through the state witnesses, the 19 state witnesses that was testified, together to reach the conclusion which the state wanted her to reach, and that she said there was no other reasonable inference that could be drawn from those facts that the state has proven.
So you make an important point there, laid out for us, for the common person, common South African, what needed to happen for circumstantial evidence to rise to the level of leading to a guilty finding. Many people talk about circumstantial evidence as if it's not worth anything, but in criminal law it is, isn't it?
There's the two specific aspects, or the two legs, two-pronged approach for circumstantial evidence to be accepted in our criminal law, and that is that all the proven facts must be consistent with the inference that the state or the party presenting it wants the court to draw. And it must be the only reasonable inference that can be drawn from those circumstances or from those proven facts. If there's any other reasonable inference that can be drawn from those facts, then the state did not acquit themselves of their onus to show beyond reasonable doubt the guilt. The magistrate found here, looking at those proved facts, it's the only reasonable, or it is consistent with what the state wants us to believe, that Mr. Malema was in possession of a firearm, unlicensed firearm, possession of unlicensed ammunition, and that he discharged it at this rally. And she also said it's the only reasonable inference that can be drawn from those specific facts.
And a key question that had to be answered, Jean-Pierre, was about whether or not there was an actual firearm or was it a toy gun, because the main centerpiece of Mr. Malema's defense was to say that was not a firearm, it was a toy gun. Talk to me about the difficulty or the ease of arriving at a conclusion that says what we see in those videos, even though one of the videos ended up not mattering for much in the evaluation of the evidence, but what we see there is an actual firearm and not a toy gun.
Yes, that is specifically, I think, where the magistrate relied on the circumstantial evidence of the cartridge case that was found on the scene the next day that went for ballistic analysis, for the firearms that has been booked out from to specific people from the security company's register, all those things, the muzzle flashes specifically on the some of the video footage that the magistrate could see, all of those things together made her come to a conclusion that the only reasonable inference that she could draw is that this was a real firearm and not a toy firearm or blanks that was being fired. As I said, she accepted the state's ballistic expert as well and rejected the defense's ballistic evidence. Not that he was not an expert, but that he did not do the proper testing or appropriate testing for her to rely on the defense witness in terms of the ballistics.
So lastly then,
the cartridge case was announced.
So lastly, then, Mr. Malema is making it clear that he's going to be appealing this decision. We await, of course, argument in mitigation and aggravation, as well as sentencing later on, and that's expected in the early part of 2026. But beyond that, what would Mr. Malema need to prove, or what would swing it in his favor if he wants to overturn this conviction?
Look, he does have, obviously, after the sentencing, a right to take this matter on appeal. With this type of convictions where it's solely based on circumstantial evidence, there's an argument to be made that the High Court, where two judges will be listening to this appeal, might come to a different conclusion when they connect the dots. Because, as I tried to say earlier, with the circumstantial evidence, there's a few dots, evidence that was proven, certain evidence, and the court needs to take it all together to get to a conclusion. Now, what the defense might argue is that two judges in the High Court might come to a different conclusion when they are connecting those dots and say that it is not proven beyond reasonable doubt. And that will probably be the argument that his team will raise, along with certain other arguments for appeal, where they might say certain witnesses was not trustworthy witnesses and their witnesses' evidence should not have been rejected. So yes, they will have to show that the High Court will come to a different conclusion based on the same evidence, unless they're taking the argument that there was some kind of legal misinterpretation from the magistrate in this matter.
All right, thank you for sharing your insights with us this afternoon. That's Pierre Venter, who is a criminal law expert, just unpacking what we heard in the judgment in the East London Magistrates Court earlier on in the week.